am a U.S. citizen who is married to a man who came to the U.S. 10 years ago by walking through the Texas border without inspection. We have 2 children together and we are financially dependent on him. Can my husband get a green card even though he entered this country illegally?
This is a common question that requires us to evaluate each individual circumstances of your family. Under current law, your husband may be able to get a green card even though he entered the U.S. illegally 10 years ago. This process is called the provisional waiver application. Generally, a person who entered the U.S. illegally or overstayed on their visas cannot apply for a green card in the U.S. through the process called adjustment of status. In the past, such person had to go back to her home country and apply for the I-601 waiver of grounds of inadmissibility. Not only this process could take a long time, but also that if the waiver was denied, she would not be allowed to re-enter the U.S. and see her family for the next 3 or 10 years. However, there is good news. Since March of 2013, she can apply for the I-601A provisional waiver before she even leaves the United States. If the application is approved, then she can be fairly certain that the consular officer will approve the immigrant visa and she will be allowed to re-enter the U.S. as a permanent resident or green card holder. Now, you need to prove that your U.S. citizen or permanent resident spouse will suffer extreme hardship if you are not granted the waiver. Such work is very evidence intensive, so we advise you to seek help from an attorney. Also, understand that this I-601A application only waives unlawful presence. If you suspect that you have other grounds of inadmissibility, such as fraud conviction or criminal records, then this would be a good time to talk to an attorney.